And we are recording. Chair Wolf, would you like to introduce the hearing?
I would. Today is Tuesday, July 13th, 2021. I'd like to open the meeting of the Education Outreach and Training Committee this month. I am filling in for Chair Chris Highland. And we have member Padmanabhan and member Yankee, who is filling in because we have a vacant seat. So, and it's we begin the meeting at 5:30.
5:31.
Okay, and Ms. Leger, if you would like to read the opening remark.
I would like to open by stating to members of the public, if you wish to make a statement during general public comment, please press *6 and unmute your telephone to speak. Please press *6 to mute your telephone once you are done with your statement. This is remote access to information and participation. In accordance with Governor Newsom's Executive Order M3020 declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Office, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Would you like to read meeting decorum?
Yeah, I'll read it, and I'll also just note for people that are listening, it's the email address to Ms. Leger is CHERLEGER@sfgov.org. Okay, and all right, meeting decorum. Any member of the Sunshine Ordinance Task Force or this committee may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Okay, please call the roll.
Item 1, call to order, roll call, and agenda changes. Member Padmanabhan? Member Padmanabhan, are you present?
Just trying to unmute.
Jaya, we can't hear you.
She's trying to unmute.
Oh, sorry.
Can you unmute, Jaya? Can you hear us?
I'll send her a quick email.
All right. I can see her. I can see her.
I can see her too, but I can't.
Can you hear us, Jaya? I don't know what's going on. Microsoft Teams.
Yeah, I just sent her an email.
Okay. Can you hear us? No, she can't hear us.
Yeah, hi, this is Jaya. Can you hear me?
Yes, we can. Can you hear us?
All right, she logged off. Let's wait a moment. Call for the rest of the roll. At least we can have the meeting after.
Member Yankee?
Present.
Member Yankee present. Chair Wolf?
Here, present.
Both present. We have a quorum.
Okay. Wait a moment. If she comes back. Can you hear us?
There we go.
Can you hear us?
Yeah.
Okay.
All right. We did roll call, agenda changes. I had heard last week, as you and I exchanged emails, Chair Wolf, that Zach Karnazes has requested that his matters be put over to August, September, and October. He wants to have one case heard at a time. This was after the agenda had been published. I also spoke with Member Yankee about this. So I wanted to put that out there.
Okay. Keep going.
That's the only change that I am aware of.
Okay, and the other three are we're going to do today.
Yes, the three anonymous against Supervisor Ronan, Supervisor Marr, and Supervisor Haney, I believe is the third one.
Okay. All right, great. All right. Yeah. Any other changes or adjustments to the agenda? Okay, so let's get a motion to continue items number 5. It's file number 21034. Item 6, file number 21035. And did I miss one? Yes, I did. File number 4, 21033. To continue to in that order, 4, 5, and 6. Number 4 to August. Number 5 to September. Number 6 to October.
Do we have a second?
I'll second that.
Okay, great. Okay, I guess I'm making a motion. Okay. All right. Any other discussion on the matter? Okay. Let's open up for public comment.
Just a moment.
Yes, please, if there's nobody else. Can you hear me? Hello?
Yes, Mr. Warfield, we can hear you. It's just, give me a minute to set this up, okay?
Thank you. It's fine. I just wanted to know if I'm muted or not.
And is this public comment on item number 1?
Yes. It's public comment on the motion to continue items number 4, 5, and 6 to the next 3 consecutive months.
Mr. Warfield, are you ready?
Yes, you'll give me a 30-second warning.
Yes, I will.
Appreciate it. Tell me when to start.
Go ahead.
This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, also P.O. Box 170544, San Francisco, California 94117. To start out with, certainly we do not have any objection to a, whatever you want to call it, I'm not sure what the word is, continuance. I'm wondering if this will count against the complainant's allowable sort of free first time, no questions asked. It's my understanding that there have been issues of disability. It's concerning to me that the efficiency of the task force is greatly diminished when people appear to be removing the hearing, asking for continuances, or even withdrawing completely what seems to be at the last minute. And I ask that there be further inquiry and looking at why is this happening. Folks are usually reliable. They have at considerable cost to themselves and their time and effort, especially when they're disabled. And I just can't believe that somebody would just simply say, oh, well, I'd rather do it another time. I think it needs to be looked into. And also, questions have come up, for example, about what the timing is, what the notification is, whether it's enough time for people to prepare or for people to provide their documentation. That needs to be discussed and looked into, and maybe as a separate item. So without objecting to, in any way, to a continuation, I do think that the task force needs to be much more cognizant and alert to what's going on. You've ripped out 3 items, and apparently there's not been a chance or a time or opportunity to replace them with others, which could have been progress for 3 other complaints. So thank you very much.
I'd like to make a public comment.
Are you anonymous?
Item, this is Zach Carnegie.
I'll find Mr. Carnez's.
Can you repeat that, please?
This is hello. Are you ready to begin?
Yes, I'm using a timer, and I please ask that people who are not speaking can mute themselves. I heard some like sighing and shuffling during the last comment.
Okay, can people mute themselves if they're not speaking, please? Sir, are you ready to begin?
Yes, and I'm using a timer, so I do not need a reminder. Thank you. I'm starting the timer now. My name is Zach Carnazes, ZKARNAZES @gmail.com, P.O. Box 40930, San Francisco, California.
Hold on a second, Mr. Fernandez. Can everybody please mute themselves? *6. Can everybody please press *6 on their phone, except for the current speaker?
Shall I
*6.
restart Mr. Carnez's time?
Yeah. I'm waiting for people to mute themselves before he begins. I'm not seeing. I have no control over this at all. So I please ask if people self-facilitate, and please press *6. I can see whether you're muted or not. And I only have 4 people out of maybe 12 that have muted. *6, please. Okay, people are not responding. Mr. Carnazes, we're going to start the clock again, and you can begin. Go ahead.
Thank you. So my name is Zach Carnazes. I'm the person that was requesting a disability accommodation. I'd like to provide some background for what really happened and why this has been very challenging for me. I got an email from Ms. Leger, from Cheryl, on Thursday, the day before the agenda was to be published, saying, by the way, you have 3 items on the agenda. I've been on vacation. Sorry, I didn't let you know sooner. That's not appropriate. Cheryl knows I have disabilities. They know that it's hard for me to have long meetings, and yet they put all my items in a single meeting and then only gave me 24 hours notice, not even 24 hours notice, before it was going to be on the agenda. So I emailed and said, please don't do this. I have some disabilities. I have some special needs, and I just need 1 item per meeting. I just got my vaccine shot. The day before, I've been sick. And it's really unfair to give members of the public 24 hours, only 24 hours to, you know, it's such a rude way to be. It's like, we're trying to volunteer our time to bring departments into compliance with public records laws. And yet we're treated like scum when we try to schedule things and communicate with this department. And it's really unfair. And it's not the first time this has happened. Ms. Leger seems to like not understand disability accommodations or hate giving them. I had to cancel a medical appointment to be here today. A medical appointment I really needed because I didn't want to risk all 3 of my items being thrown out because it still was not taken off the agenda, even after I made that request 5 days ago. That's it for my time.
Next speaker.
May I speak?
I'd like to speak as well.
All right, anonymous.
I think I was first. All right. Please let me know when I may begin.
Okay, you may begin.
Thank you. This is anonymous number 3. A member of the public suggested I just go by the same number each time, so I'm just going to go ahead and call myself anonymous number 3. I have personal knowledge of the emails that were sent to schedule today's hearing and the notices. That original notice went out on July 6th from the SOTF mailing list to the anonymous who's on the agenda today, which is not me, and various people who work for the city. And as far as I can tell, Mr. Carnazes is not even on the notice list sent on July 6th. And that July 6th notice tells people that they have to have their documents by July 5th, which is 48 hours, which is a very, very short time. And Mr. Carnazes doesn't even appear to be on, if I'm reading this correctly, the list of people who this was sent to. And so it's not just Mr. Carnazes that gets a very short notice period. Apparently he got an even shorter notice period. It's everyone. And so I would urge that this committee and maybe the task force as a whole consistently give notice of appearance to both all complainants and all respondents as early as they can, to both facilitate, for example, potential disability accommodations, but also what Mr. Warfield said. For example, I was noticed I'm not here today, but for some other hearings quite a bit ahead of time, so I could take those cases off because, for example, I had agreements or whatnot. And I think that allows you to schedule more people's complaints, right? If people can remove them from the agenda as soon as possible. Thank you very much.
May I speak?
Just a moment, sir. You ready, sir?
Yes.
Go ahead.
Okay, speaking to the motion, I'm Patrick Monette Shaw, and in all fairness to Ms. Leger, I am also disabled, and on multiple occasions, she has provided me with reasonable accommodations. So I find it objectionable that she is being accused wrongly of not making reasonable accommodations. Thank you.
Do we have another speaker?
Last call for public comment. Hearing no more. Okay, I just want to just state that when I reviewed the agenda, it was at that time there was no notice for any changes or adjustments, so we could not remove it once it had already been publicly posted. So that's why we're doing this motion here at the moment to accommodate Mr. Kornaitzis for a reasonable accommodation. As far as the other comments are concerned, I'll take them under advisement, and we are trying to make some adjustments to try and provide more time before the posting of an agenda in order to kind of help the situation. Members, anything else? Okay, I guess we're ready for a vote. Please call the roll.
Chair Wolf,
Aye.
Chair Wolf, aye. Member Yankee,
Aye.
Member Yankee, aye. Member Padmanabhan,
Aye.
Member Padmanabhan, aye. The motion to continue items 21034, 21035, and 21036 to 21034 to August, 21035 to September, and 21036 to October.
Okay, thank you. I just want to also note for the record that at the last full task force meeting, during the administrator's report, there was a proposed new timeline that speaks to this issue to try to create more time. So I would refer you to the minutes of that meeting. Okay, let's call the next item. Number 2.
Bruce, I think we have to deal with the item number 1, section A. Shall the Education Outreach and Training Committee waive complaint procedure rules to allow more than 2 complaints to be heard in the same meeting by the same complainant?
Right. Yeah, we would have to waive our.
I'm sorry, I didn't hear you.
We would have to waive. Members will have to waive our complaint procedure rules in order to hear these 3 items on the agenda today.
Do we want to create a motion for that?
Is there a motion?
Sure. This is Member Yankee. I will move to waive the complaint procedure rules and allow more than 2 complaints to be heard in the same meeting by the same complainant.
For this meeting.
For this meeting.
And I will second it.
Okay. Let's open up for public comment.
Yes, please.
I have a public comment as well for this item.
Mr. Warfield, ready?
Yes, please. You'll give me 30-second notice and let me know when to start.
Sure.
Thanks.
Go ahead, sir.
Peter Warfield, Executive Director, Library Users Association. Library Users 2004 at yahoo.com, and also P.O. Box 170544, San Francisco, California 94117-0544. I'm not really clear why this has now appeared over and over again, even when there hasn't been any kind of need for it. And I do wish that this seems to be coming up a lot, if not at every meeting, at least in the last couple of months that I've noticed it. I don't understand. It seems to me if you have rules, you should generally stick to them. And if you don't stick to them, that there ought to be some justification or explanation so that people can make a decision as to why this is different and should be treated as an exception to the rule. Generally speaking, I don't recall hearing any of that, and I certainly have not heard it today. It seems to me that if there are to be exceptions to the rule, there should be an explanation. If the rule is too frequently changed, perhaps it should simply be removed from the list of rules. I don't have any issue with such kind of a change to the rules for the meeting if both sides have been asked, and if both sides really and truly wish it to be this way or agree to it. I would certainly like to know what the parties have said, or even hear them directly with respect to this kind of a thing. I think, as Zach Carnese said, it can be a burden, even on people who are not disabled, to do more than 2 agenda items, 2 hearings in a single meeting. It can be a very great effort to prepare and a very great effort to present even for 1 agenda item. So that also brings us backwards into the procedures of how these things get put on the agenda. Has anybody been asked before it was put on the agenda? Is there any rule for asking the parties prior to putting it on the agenda? So I think there really needs to be a look, an active look, not just at last time's minutes about what was discussed about maybe we ought to consider something, but it's clear to me that there's some serious questions about what the procedures are and what the procedures ought to be. With respect to, pardon?
Your time is up.
I thought you were going to give me 30 seconds warning.
I did.
Okay, thank you very much.
Any other speakers?
Yes.
Is this
This is
Mr.
Zach
Carnese?
Thank you. I'm using a timer, so I won't need a warning. I'm starting the timer now.
Okay.
My name
Go
is
ahead.
Zach
Go ahead, sir.
Carnese. I can be reached at zkarnazes@gmail.com, P.O. Box 40930, San Francisco, California, 94140. I share the concerns with the previous comment about waiving the rules. I mean, rules are there for a reason, but I think if there's consent from both parties, then it makes sense, right? So it's hard because this is a little out of context. I'm assuming this is for Anonymous's 2 complaints that are later in this meeting. And if Anonymous and the defendant are okay with that, then sure, why not? But it's, I think the last comment was very articulate, that rules are there for a reason. And if they're not going to be followed, there should be a good reason for not following them. Having multiple complaints is an extremely heavy burden for me. There's a lot of evidence to gather depending on your complaint. And sometimes these complaints are not heard for many months. So there's months of evidence to gather. And that's hard work. We don't get paid anything. Members of the public get paid nothing. Meanwhile, members of city government that are paid from tax dollars make a lot of make these kind of demands on folks, and they don't ask in these emails, hey, would you like to present 3 items? Would you like to present 2 items? Is that okay with you? They don't even ask us. They just say, you have 3 items. You have more than 1 item. And this is the first time I've even heard that there's a rule that doesn't allow that. So that seems a little strange to me, and I hope someone can look into it. Thank you for your time.
Next speaker.
This is anonymous number 3, if I may speak.
You ready, sir?
I am.
Go ahead.
Thank you. This is anonymous number 3. I am not the same anonymous who has the 3 complaints before you that you are making this motion on. I'd just like to give a different perspective. Sometimes, so as I think is now widely known, I file a lot of complaints. it is useful to have multiple complaints at once because it means you can bring the city into compliance quicker. However, I completely agree that it should be done with the consent of the parties, if at all possible. The actual rule, my understanding of your rule, it actually says the rule can be waived. It's not like the other rules which don't have a built-in way of waiving the rules. I believe this rule says the chair of any committee or the chair of the SOTF can just waive the rule. And I would say when it works correctly, Ms. Leger does let you know, and I've been told, for example, the last full task force, I was told, hey, she had proposed 3 hearings of mine. I asked her to move one later and ideally give that slot to someone else. I don't know if that last part happened, but a conversation can occur, but of course that conversation requires sufficient notice so you know what hearings you have proposed. And again, if there are any issues from that, I think that's another issue that can be at least, if not solved, ameliorated by just increasing the notice time. But if this anonymous is here and wants to do all of them, well, one would assume that the other 3 respondents are here, and it would just be a waste of everyone's time not to do them if everyone's here. Thank you.
Next speaker. Let's call for public comment. Okay, public comment is closed. I'll just say the reason why this rule got in there, the task force created it, and it wasn't so long ago, it was just a couple of years ago, was because of too many people requesting that all their files be heard in one meeting, or that they had multiple files that were against the same respondent, but the complaints were so different from each other that they couldn't be combined. And so it was taking up too much of the agenda, and there wasn't enough diversity of different parties that should be given an equal or equitable chance to have their cases heard. So that is the reason why we created this rule, to limit just 2 files per meeting for the petitioners. Now, as far as the respondents are concerned, for instance, in our agenda today, there are 3 different respondents. So I'm not quite sure how a response from them with regards to waiving the rules would be at that point. If this was a more lengthy agenda, I think members would take a little more consideration as to whether to allow all 3 at that point. But since these are the only 3 on today's agenda, I would say it also helps with our backlog if petitioners are interested and willing to take on an extra when they have multiple, a large amount of multiple complaints with us. So that said, members, any other comments? Okay, let's ready for a vote. Okay, let's call roll.
Yankee?
Aye.
Member Yankee, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member Yankee, second by Member Padmanabhan to waive the complaint procedures rules for this meeting.
Okay. And I'll also just note for the record that, in all deference to the respondents, I mean, today is also they're in the middle of their own meeting. So I probably should have been better looked at. This isn't my regular committee to chair or to be part of, and so it was a little bit of adjustment for that. So, all right, let's start with now we're into item number
2.
2. Go ahead.
Item number 2, adoption of the minutes for the June 8, 2021 Education Outreach and Training Committee meeting.
Okay.
Does anybody have any? I have the minutes right here. Does anyone have any suggestions or changes or?
This is Member Yankee. I have just one quick one, Cheryl,
Okay,
and that's on item number 2. I believe Mr. Warfield's email address should be at yahoo.com, and it has it as
Gmail. Yep.
gmail.com. I'm assuming that's what he said then. I wasn't obviously here for that, but that seems to be his address that he uses.
You're correct. I apologize to Mr. Warfield. Thank you, Matthew.
That was all I had.
Okay, anybody else have any changes?
Member Padmanabhan, do you have any changes since you were at that meeting?
No, I don't.
All right, let's open up for public comment.
Yes, please. Can you hear me?
Yes, just a moment.
Thank you.
You ready, Mr. Warfield?
Yes, you'll give me 30-second warning and tell me when to start, please. Yes?
You may begin.
Thank you. Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and also at P.O. Box 170544, San Francisco, California 94117-0544. The error in the email address, thank you very much for Member Yankee for speaking up, for noticing, and for asking for the change. So the first thing I'd like to say is I would like the motion to specifically include the error and the correction, because people who might have sent or tried to get in touch with the wrong domain name, which has been sitting out there in public, posted for a month, it might help them understand why it didn't work. I would also like to ask that you not doctor the document itself, but also not leave it alone to sit out there into eternity with the wrong email address, which, as I've said before, could be worse than nothing. What I'd like to ask you is to specifically in your motion specify the error and exactly the correction and put it in the minutes and say that it should be in the minutes. And I would like to ask that you also make a note, as is done with newspaper articles and so on, in the draft that indicates right there that that is what was published, but it's wrong, and that the correction is such and such that was noted in the July meeting. That's what I think should be done to make it right. I also have requested in the past and again that I consider it important to include all of the information that I give when I speak, certainly the contact information, which is important enough to repeat repeatedly. And I'd like to see that at every point in the minutes. Otherwise, I think that the minutes are somewhat better than in the, some of the others I've seen recently, but
30 seconds.
Thank you. On item 3, I don't think that I got out of there without saying that I think that next request is a disaster for the public. And I also don't think that I got out of saying that very same thing on another item in the agenda where it has been basically bowdlerized and left out. He finds that he would like more information on next request because he finds it confusing. 9. It is confusing. It's not that I'm confused. The issue is it's confusing. Thank you.
Next speaker.
Anonymous number 3, please.
Go ahead, sir.
Thank you very much. So the full Board of Supervisors notes corrections in a way. They just put a little bit of red text at the top of their minutes, so that the final minutes at the top, Ms. Cavillo puts, oh, this and this was corrected on this and this date from the draft. And I think that might be a great way to do it, so that when people look at, because you guys don't keep on the on your main website, you don't keep a direct link to both the draft and all the corrections and only the final minutes. You only keep to whatever the latest version of the minute is. So that final version of the minutes could just have the correction listed at the top, so people know. And that's the one most people will likely go to, not the one kind of in the agenda packet of a different meeting, right? They'll go to the one that's directly linked from your website. So you might want to consider such a red correction text right at the top saying what the corrections were from the draft. Thank you.
Next speaker. Okay, hearing no more public comment. Public comment is closed. Are we ready for a vote? Okay, please call roll.
What is the wording?
It's a motion to approve the minutes.
With no changes?
No one has made any adjustments. Thank you, Mr. Warfield.
Thank you.
Please call the roll.
Member Yankee?
Aye.
Member Yankee, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the June 6, 2021 minutes with requested corrections and adjustments has passed.
I believe it was the June 8th and not June 6th.
I'm sorry. Yes, it's June 8th. I couldn't read my handwriting.
Okay, thank you. Please call next item.
Item number 3, public comment. Members of the public may address the Education, Outreach, and Training Committee on matters that are within the committee's jurisdiction, but not on today's agenda.
May I speak first, please?
Wait for Ms. Leger to get the clock reset. Thank you.
May I speak, please?
Yes, one moment. Wait for Ms. Leger for the clock. She's resetting the clock.
I'm sorry. Are you ready, speaker?
Yes.
Go ahead.
I'm Patrick Manette Shaw. Again, I have a disability and will not be able to stay on the phone for several hours until you reach agenda item number 10. As a public accommodation, could you please let me quickly say this? Both the City Attorney's Office and the Department of Public Health have recently violated the time limits on my public records requests, as have other city departments. I'm sure other records requesters have faced the same problem. This is not a one-off, unique to me. Rather, it's a systemic, recurring problem. I feel strongly that this EOT committee should recommend to the full Sunshine Task Force that a system-wide advisory be sent quickly to all departments clarifying the Sunshine Ordinance's time limits. Thank you for this reasonable accommodation.
Next speaker.
May I speak?
Wait for the clock,
May I
please.
speak?
Sir, are you ready?
Yes.
Go ahead.
My name is Zach Carnazes. I'm starting a timer now, so I do not need a 30 seconds warning. Thank you. I have a lot of concerns about accessibility for these meetings, as I've conveyed before. It's not been made clear whether or not I will be penalized and lose my right to a continuance for the items that were continued today, due to the fact that they were actually reasonable disability accommodations that were made 5 days ago. And I made those accommodations the day I found out that the agenda was going to be posted, which was on the 8th of July. I have done a internet research. I'm not able to find the ADA coordinator for this office, the person who handles disability accommodation requests. As far as I'm concerned, that request was denied. If you don't issue a yes or no and you say, well, just come to the meeting and we'll decide then, that's a denial of a disability accommodation request. And it should be made clear that that's a denial. And that is my issue here with, this has happened now multiple times. I would really appreciate it if someone could please email me the ADA coordinator contact information so that I can communicate with them about these issues in the future, as well as a copy of these meeting minutes as soon as they are available, so I can make sure that they are reflecting accurately what my statements are here today. I think I can only speak to myself and my own experience as a person with disabilities. We are not given enough time to prepare for these meetings. 7 days would be the bare minimum before the agenda is published, that the public has a reasonable amount of time to gather the paperwork, which can extend months or years, to be prepared as petitioners to present before you all today. Please consider giving us 7 days notice so that we can prepare our documents and have a swift and convenient, or not convenient, but I'm just not feeling good, but just a swift meeting and make it easier for everyone. I don't know Cheryl Lizzie personally. I mean this no attack against her. I'm just trying to improve things for myself and fellow disabled people and members of the public. Thank you.
Next speaker.
This is anonymous number 3. May I speak?
You ready, sir?
I am.
Go ahead.
Thank you very much. I don't know where to say this, but your motion earlier today, the numbers were wrong. It's not 21034 through 036. It's 21033 through 21035. So I don't know how you'd need to correct that, but yes. Anyway, I actually want to talk about what I believe is the purpose of this committee, which is educating and training the rest of the city. My understanding is the SOTF is not allowed to assist in training the city when the city attorney goes annually and does this training. I think you should insist that you are allowed to be part of that training. Your interpretations of Sunshine are significantly better than the interpretations of the city's own lawyer, for possibly obvious reasons that they are the city's lawyer. And I think you should insist on that right. But I think you can also educate the city through every complaint. And I don't just mean through the order of determination, but your request for a complaint response. You have 5 questions. And I think you should add to that response, the formal service of the complaint, certain questions. First, was any information withheld? Provide the written justification of withholding of information. Was any information redacted? Provide the key justifications for each redaction. Did you search personal property of employees? Did you request contractors to produce relevant records in their possession? And if the complainant has made specific allegations in a complaint, please admit or deny each one. And you could also put at the bottom, failure of the city to respond in a complete and timely manner to this complaint or to appear at any SOTF hearing may result in a determination that you are in violation of the Sunshine Ordinance and an order to disclose additional information. The city needs to take the Sunshine Ordinance and this task force seriously. And I think you can do both of those things by making more rigorous your request for a response to a complaint. And I think it should be pretty simple. Many of these are yes/no questions, and they would just allow you to find these violations very simply. Ideally, it would also educate custodians who may not know any better that these are part of the Sunshine Ordinance. So please consider making some of these things part of your formal service of complaint process. Thank you very much.
Next speaker.
Yes, please.
You ready, Mr. Warfield?
Go.
You may begin.
Thank you. Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and at P.O. Box 170544-0544. First of all, I want to say how lovely it is to hear all the folks who just spoke. I think all of them have excellent points. With respect to their comments this time, certainly there, I think, needs to be a reconsideration of a whole variety of things, including the Sunshine Task Force's complaints procedure. Whatever you call it, I don't think the complaint procedure talks about how you approach the respondents, although I certainly think that it should in more detail, as suggested, for example, by Anonymous 3. I would further say that I would like to see the task force itself have a procedure for each complaint so that it specifically addresses every single one of the allegations that a complainant makes. I have seen too often, and not just with this group, but in the past as well, on occasions, where it seems as though through inadvertence or unpreparedness, whatever it is, the task force will consider the obvious or the things that are obvious to such certain folks, and then forget about one of the violations that was specifically raised by a member of the public. I'm glad to say the opposite happened with respect to my specific complaint in June, where Dean Schmidt actually added a complaint or added a violation, which was quite right. We had mentioned it, but we hadn't specified the law that applied, which is the cost of attending a library commission meeting when it takes a toll call in San Jose to get through to it. So I think that there's a whole range of things that the task force can and should do to consider how it is treating its process, and in particular how it treats its public. I think Zach Karnazes is quite right, and it has happened before to him. It's also happened to other people. You heard from Mr. Chafee that he didn't get a notice. He got a notice that was date marked after the date of the closure of the agenda packet, and so on and so forth. I would like to specifically request on our complaint that the EOT take it up for follow-up. Also, the complaint committee, the compliance committee, because the library was not specific in what they understood was wrong. They didn't seem to understand some of the issues. They talked about tech issues in a very vague way. I'd like this to be taken up with follow-up. Thank you.
Next speaker. Last call for public comment. Okay, public comment is closed. Thank you. Please call next item. And just note for the correction that the items that were continued was for 210, 33, 34, and 35. And now we are on.
Can anyone please offer clarification if those will count against my right to a continuance, please?
I'm sorry. I'm sorry. You have. I usually don't take things out of turn here. What is the issue?
It's been requested twice in this meeting to know if the three items being moved will count against my right to have a continuance. Because I have a right to a continuance, right?
No, it will not.
Thank you so much.
Okay, please call next item. It's marked item number 7, 20086.
Right. Item number 7, 20086, complaint filed by Anonymous against Supervisor Matt Haney for allegedly violating Administrative Code sections 67.3 A and D by failing to provide notice of meeting of policy body, 67.5 failing to allow open and public meetings, 67.6 failing to post the time and place of the meetings, and 67.8 by failing to allow agenda disclosures. On March 23rd, 2021, the Education Outreach and Training Committee heard the matter and continued it to the call of the chair due to the non-appearance of the petitioner. The petitioner was informed of the complaint committee action by email.
Is both parties here? Is the petitioner here? Petitioner Anonymous, are you here? Is the respondent here?
Can you hear me? This is Han from Supervisor Haney's office.
Yes, we can hear you.
Hi. Yes, I will be appearing on behalf of Supervisor Haney as he's still in the board meeting today.
Understood. Please stand by. Is the petitioner Anonymous here? Okay, I'm going to ask if the petitioner is not here for this item. Members, I'm wondering if we should deal with each one independently or deal with them all at once. As far, because we're going to have to make a decision as to whether to continue the item. It was already continued once. We usually will close the file, and the petitioner has opportunities to reopen it as per our complaint procedure. I don't want to take up the rest of the staff's time. If we want to do it all at once for all three of the items, or to do them one at a time. It probably won't take that long. What's your pleasure?
This is Member Yankee. I think it makes sense to, handle all three at the same time with a single motion, if that's what we're going to do.
Okay.
I would agree with that only, but the problem would be then that we would have to hear each respondent separately.
No, what I'm suggesting is if the petitioner is not here, the complainant is not here, and all these three items have already been continued once. Our rules we can choose to close the files. My question to you is, shall we take them one at a time, or shall we just do all three? Since the petitioner is not here, the complainant's not here.
Okay, in that case, let's just take them together.
Okay. I'll entertain a motion. This would be I'll move it. I'll move close the files of file number 20086, 20087, and 20088.
I will second that.
Okay. Public comment.
Anonymous number 3, please.
Hang on.
Hello? Hello?
We hear you.
Oh, hi. This is Jennifer Lee. I'm here on behalf of Supervisor Hillary Ronan.
Yes.
Can you give some clarification on what it means? So you guys have closed it so we don't have to present or do anything for this meeting?
Sure. So our rules are that we'll usually allow one continuance if the petitioner or the complainant does not appear, but not a second time.
Okay.
And if they wish to reopen the file, they can apply to reopen the file. Right now, what we're going to do is we're going to close the files, which means they'll be, more or less, we don't call it dismissed, we just close the file, which means that it won't come up again until there's the petitioner may or may not take action on their own. Is that clear?
Thank you so much for this Yes, thank you so much for the clarification.
Okay, great. Okay, we'll continue with public comment. I think we had anonymous number 3 speak up.
Sir, are you ready?
I am.
Go ahead.
Thank you very much. I understand you're following your rules, and there's nothing much to be done here. I would agree with the many prior comments at your full task force of many members of the public that I hope that the task force changes how it works things and examines potential violations of the law, even if the member of the public isn't willing to. In this case, as discussed by, I think at the other time this was discussed, as both I raised and member Schmidt raised, there is a distinction between what is a Sunshine Ordinance meeting and a Brown Act meeting. And while it appears that these three respondents did not violate the Brown Act, which has an exception for gatherings like this, that it has to be within the jurisdiction, the subject matter jurisdiction of the body, the Sunshine Ordinance's phrase in that exact exception does not include the fact that if it's not a discussion under the subject matter jurisdiction, then it is no longer a meeting. That is not in the Sunshine Ordinance. And it's unfortunate that it appears this issue will not be handled on its merits. I'm just going to say, if this complainant does not proceed, I will proceed on that logical argument myself. The Board of Supervisors should know, then they should read carefully the difference between the Sunshine Ordinance's definition of a meeting and the exceptions to such a meeting being noticed versus the Brown Act's definition. Thank you.
Next speaker. Last call for public comment.
Yes, please. Can you hear me? This is Mr. Warfield.
Yes.
Mr. Warfield.
You'll give me 30 seconds warning and let me know when to start.
Yep. You may begin.
This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and at P.O. Box 170544, San Francisco, California 94117-0544. First of all, I think in this interest of equity, I want to thank the two supervisors and or their representatives for being there. But I don't think you should stop just as soon as you gotcha on the complainant. The supervisors are required also to be there, and you absolutely should make sure that they are all here and ready for their complaint hearing. And if they're not, if presumably one is remaining, Supervisor Marr, then that should be a violation, as it usually is. Had you reversed the process, you would have gone through the three supervisors and then the complainant. But in the interest of equity, I think you should check for the attendance of Supervisor Marr. I want to say something about mechanics. I thought I was unmuted. When I spoke up and said, I would like to speak, I heard, yes, or we can hear you, or something like that. Please. It turned out I was not unmuted, I was muted. And so now I'm speaking last at the very moment that the Board of Supervisors is having public comment during their meeting. So let me say that, first of all, I don't think that you should ever have meetings on the same day as the Board of Supervisors for precisely the reasons that I'm struggling with, and for the reasons that the supervisors are having to send during an important meeting. Three of them have to come commanded to be present at a hearing of the Sunshine Task Force. At least they have multiple staff people, presumably, that can handle it. But I think that it's very wrong, and we worked hard to get the full task force to not meet on the same day as the supervisors. So they changed their Tuesday meetings to Wednesdays, but now seem to have gotten all the committees meeting on Tuesday in a direct conflict with the Board of Supervisors. And I think that's very wrong and should be changed. With respect to these three complaints, I think the same problem exists. What happened to the complainant, who must have gone to a considerable trouble to do this? And why is there such a last-minute situation where you're not able, or for whatever reason aren't, substituting anything and making essentially a giant waste of time? If you say that multiple hearings in one day is going to get you through the backlog quicker, well, it's not happening if you don't have the meetings, because for whatever reason, not enough notice and so on and so forth. So I hope you will see whether Supervisor Marr is there and consider the timing and whatnot of all of your procedures. Thank you.
Next speaker. Okay, hearing none, public comment is closed. We're ready for a vote? Hearing no objection, please call the roll.
Just a moment. Chair Wolf?
Aye.
Chair Wolf, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, moved by Chair Wolf, seconded by Member Yankee to close files 20086, 20087, 20088, and prepare an email to the petitioner letting them know that the cases have closed.
Thank you. Please call next time.
Item number 10, shall the Sunshine Task Force send system-wide advisory about the time limits of public records disclosure requests?
Okay, so I requested that the committee hear this item because I feel it has to do with the jurisdiction of education, outreach, and training. We hear a considerable amount of cases around timeliness, and a lot of it is just purely timeliness. And there have been lots of suggestions from the public, from I've heard from city staff over the years that these are so trivial that they take up more time than it's worth. So, considering that a lot of our the complaints that we hear are based purely on timeliness, more procedural than they are on specific details that merit a lot more research and understanding. I think it's time that the task force starts sending out advisories on our position and the way we interpret and understand the Sunshine Ordinance. Now, in this case, there is clearly a discrepancy between the timeliness that is in the city attorney's good government guide that most people cite, with which we have made painfully clear to the city family that some areas, including this one area, is not in congruence with the Sunshine Ordinance. In the good government guide, it says 14 days. The California Public Records Act allows for an enhancement to increase efficiency and more transparency at the local government level. The voters had passed a law to do that, now called the Sunshine Ordinance, and the Sunshine Ordinance has made that efficiency and expediency happen by reducing that 14 days to 10 days. It's not 10 days and then another 14 days, or it's not 14 days and another 10 days. It is 10 days. And so I think it's worthwhile at this point to send out a message to everyone, considering that we're not invited as per 6733 of the admin code. Last sentence of the paragraph states, I quote, "Annual training shall be provided by the San Francisco City Attorney's Office with the assistance of the Sunshine Ordinance Task Force." I have gone to those trainings. They know that I'm in the room. They happen at the War Memorial Auditorium when they meet in person. And we are not asked for any assistance at all. We're not asked for assistance when they create the Good Government Guide. We're not asked for assistance when they give workshops or tutorials, if they give workshop tutorials. We do get called, some of us as task force members get called independently to present the Sunshine Ordinance as a training to various commissions, mostly advisory committees and councils. but we just are not afforded the ability to express how the community interprets and wants the Sunshine Ordinance to be interpreted. So with that, starting the ball rolling, I think we should make it very clear as to what the proper time to respond is under 6721 and under 6725. And I'll stop there if you have any other comments or discussion or motion.
So I have a question about, the item number 10 says, shall SOTF send system-wide advisory about the time limits? What does system-wide mean? Where will it go?
Send it to everyone, all departments, for distribution.
And the time limits, is it 10 business days for Sunshine or 10 days?
It just says 10 days. And so we assume that it's, unless it says business days. So in 6725B, if the voluminous nature, quote into the record, if the voluminous nature of the information requested, its location in a remote storage facility, or the need to consult with another interested department warrants an extension of 10 days as provided in the government code. This is in the CPRA, 6456.1. The requester shall be notified as required at the close of business, as to the close of business on the business day following the request. So the extension is 10 days, but the notification is in business days. And then in 6721, I think it's, is it B? Yeah, in B, 6721B, and I'll quote, a custodian of public record shall, as soon as possible and within 10 days following receipt of a request for inspection or copy of a public record, comply with such request. Such requests may be delivered to the office of the custodian by the requester orally or in writing by fax, postal delivery, or email. If the custodian believes the record or information requested is not a public record or is exempt, the custodian shall justify the withholding of any record by demonstrating in writing as soon as possible and within 10 days following the receipt of the request, and that the record in question is exempt under express provisions of this ordinance. So that's the two major areas that I'm focusing. I want to bring to our attention. If there are other areas with regards to timeliness, then let's bring those forward too, and make a consideration. We might hear some more thoughts from the public. Also, any other discussion? Shall I open it for public comment? Shall I? Yes. Okay. Let's open it for public comment. First speaker.
Yes, please.
Please wait for Ms. Leger.
Mr. Warfield, are you ready?
Yes, you'll give a 30-second warning and let me know when to start.
Okay, you may begin.
Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com. Also, P.O. Box 170544, San Francisco, California, 94117-0544. I'd like to repeat again the problem that I had on the previous item. I think it is useful, as I've otherwise mentioned, for folks to identify who they are when they're speaking, particularly the members of the task force, and especially in a larger meeting than this, but also to say yes and identify who it is that you recognize as wishing to speak, because otherwise you might be saying yes to several people, none of whom or only a few of whom are actually requesting to make public comment, and who may think mistakenly that they are able to make public comment when they are not. I'd also just like to mention as an aside that on your system, there is silence when I press *6, and that's sort of strange because it's quite different from the other places that I've been with these sorts of group meetings, Zoom meeting, or Zoom or WebEx or Teams. First of all, with respect specifically to the recommendations that Chair Wolf has made, I would agree. I would certainly leave it to the task force to figure out what the law says with respect to what's required in response times. But I would also go further, and I've been asking for this previously, and I think the task force has taken some stabs at it before, and that is to make it crystal clear when and for how long the restrictions on immediate disclosure request times and anything else that has been changed by the governor and by the mayor. I think it's urgently required not only to let people know what, in plain English, are the changes that emergency orders have made to the Sunshine operation and the Sunshine users, which is pretty much the whole public. And that should be, first of all, made clear to everybody all around. Second, I think it's urgent that the task force exercise its role and in advising on policy to urge that those restrictions be chopped away. California, presumably on June 15th, opened up. Why are we still having the restrictions, as far as I know? And what are those restrictions and how long do they last? So I think that that is an absolutely crucial role that is part of your 67.30 and following obligations under the law and should not be put as a secondary.
Your time is up, sir.
Thank you very much.
Do we have any other speakers?
Anonymous number 3, please.
You ready?
I am.
Go ahead, sir.
Thank you very much. First, I think this is a fantastic idea. And unlike the advisory sent by the city attorney's office, who used many pages and case law and all sorts of stuff, I think your advisory is 3 bullet points. If someone sends you a normal records request in San Francisco, you have 10 calendar days to comply with that request. If someone sends you an immediate disclosure request, you have 1 business day, if it is sufficiently simple, to either fully comply, or if it's not, to provide a notice of extension for 10 calendar days. That's it. I do think there's one more timeliness bullet point, which is the assistance timeline. I think that's 7 days in 6721C, but I don't have the law in front of me. And you might as well put that as a 4th bullet point in there. And I think it should be very short and sweet. This is the task force's interpretation. I assume the task force would vote on this by majority vote and send it out. And they'll know if they're not going to follow this, you're going to find them in violation. And just be very straightforward about it. And I very much agree that it should reduce the number of those violations. Or ideally it would, and it would no longer be an excuse if after this they're still just not even responding. I agree that there needs to be more research upon why isn't the emergency order lifted and what this task force can do, if anything, about that purported suspension of the timeliness requirements. I do have suggestions for additional system-wide advisories, as you've called them, but I guess I'll have to say them in the future agenda items. But please do consider making this very short and sweet and adding a bullet point about deadline for assistance. Thank you.
Any other public comment? Last call for public comment. Okay, hearing none, public comment is closed. Yeah, I would agree in adding 6721C with regards to the assistance provision, that requires a 7-day response. But again, I also want to make clear, I think the task force should make clear to the city family that there is only one response time period, not two. Just because the CPRA says one thing doesn't mean that that is in addition to what the Sunshine Ordinance provides. In this case, the ordinance supersedes the CPRA. It's kind of one of those strange reversals of reality where most of the time state law supersedes local law. In these laws, it's the reverse. Local law can supersede state law, but it only can do that at that local level that it applies to. So we have a number of different points here. I would be entertaining a motion to make this a recommendation to the task force for approval. And then if the task force so chooses, to then we'll have our administrator put it on letterhead, and we'll get it out into inter-office email or mail, however it gets distributed throughout the city, and to all the city departments. So let's recap. Let's start with 6721. It'll be in reference to 6721B for the basic first level of timeliness. It would be 6721C for that would so B would be with regards to 10 days. C would be for assistance, and that would be with a 7-day response. I think we should also, just for the sake of, as we're on the same matter, include 6721D with regards to the engagement of the supervisor of records, which requires the supervisor of records to respond within 10 days. And then 6725 with regards to the immediacy of response being no later than the close of business day of the following day of the request, and that and then in 6725B the extension. Okay. Now, one last item. We've had a few cases this year where we've heard respondents referring to an immediate disclosure request as not being qualified as an IDR. And instead, they would then treat it as a standard request. Okay? To me, it really doesn't quite matter because you still have the 10 days to respond. What difference does it make? Most of the time they try to do that because they don't want to be cited for the timeliness issue on having not responded by the end of the following business day. So if they say this doesn't rise to for an IDR, then they'll say it's a regular request, and then the response time is 10 days. There is no next business day period. That disappears. That's not even applicable in 6721. So I think it's worthwhile to make the reminder that the task force regards IDRs independently of a standard 6721 request, and that they cannot be converted. One cannot be converted into the other by anyone. And that we stand that until we're told otherwise by a court. We stand that to be true. Does anybody have any comments on that?
Sure.
No, I'm not public comment, not yet. I'm talking to just the committee members first. Any discussion? I'll put it that way.
This is Member Yankee. I would just say I agree. So I really don't have anything to add.
Okay. Member Pud.
Member Padmanabhan, and I just want to clarify that this is in the instance of when an IDR is not particularly stated in the complaint. Is that right?
Right. Yeah. IDR. It has to be specifically formatted. So it has to have the words, immediate disclosure request placed at the top of the request and on the envelope or in the subject line of the email or the fax or whatever, however it's being transmitted.
And so if it is, so what you are saying is that if it is not explicitly stated there, then the departments cannot convert that to.
If it is stated properly, if it is formatted properly, they cannot convert it to a 6721 standard request. If it doesn't say immediate disclosure request where it's supposed to say it, as per 6725A, then they can treat it as a 6721 request. It's a technicality, but the law is there. It's very explicit. It gives a pretty simple description as to how to do it, instruction on how to do it. So, and frankly, I think the last line of 6725A really speaks to the crux of all this with regards to that, where it says maximum deadlines provided in this article are appropriate for more extensive or demanding requests, but shall not be used to delay fulfilling a simple, routine, or otherwise readily answerable request. I think that actually should be in the preamble of this section. I think that that is a very powerful statement, with regards to, expediency of producing the public's documents and the public's records.
Okay.
And maybe we should start off our letter with that. And I often think about, when they say provided in this article, is section 6725 an article, or is the whole Sunshine Ordinance an article? So maybe I'll have to ask a question of our legal counsel as to what in a legislative construction what that actually means with regards to the code here.
Excuse me, Bruce, Chair Wolf?
Yes.
Yes. Could you please refer to what part of the ordinance you were reading so I could put it in the preamble?
Yeah, 6725A, last sentence.
Thank you so much.
Okay. All right, let's open up for public comment, see if we get some more ideas.
Yes, please.
Mr. Warfield, are you ready?
Yes, please, and you'll give me 30-second warning, and
Yes, I
I'm
will.
going to start. Yeah.
Okay. Go ahead, sir.
Go.
Go ahead.
Little problem hearing. Thank you. Peter Warfield, Executive Director, Library Users Association, Library Users 2004 at yahoo.com, and also P.O. Box 170544, San Francisco, California 94117-0544. First of all, the last thing that I heard being said, I think is very important and definitely deserves to be placed very high, and that's because all of the ordinance says it gives time maximums, but unlike some of your prior, at least one of your prior attorneys actually, and some people's interpretation seems to be that they get a free pass for the maximum time. So these actually are not flat passes for 10 days or any other time as I read it. Section 6721A says that the response there has to be without unreasonable delay. Section B for boy, a custodian of a public record shall, comma, as soon as possible and within 10 days following receipt of a request, comply with such a request. It's not a 10-day pass. If it's something fairly straightforward and the person did not make it an IDR, they don't get 10 days to turn over something that's obviously simple. And Section C talks about shall, when requested, the respondent shall, when requested to do so, provide in writing within 7 days. Let me repeat, within 7 days following receipt of a request. So these are maximums, not free passes for 10 days or extensions or anything else. And I think that needs to be very, very clearly stated. I know it might be sometimes squishy or seem squishy to enforce, but I think that, for example, if somebody has a simple request, I'd like an agenda, I'd like minutes, whatever it is, they don't get 10 days. They shouldn't get 10 days. It shouldn't be necessary to have 10 days. There's another issue that I feel is very important, and that is I'd like you to consider adding a request for making a request, the access to a request enforced. And when they close City Hall down completely and cut the telephones off, then I don't think that you have an ability to do what Section 6721A says, which is that you can request in all these different ways without an appointment. And that's what should also be provided. Thank you.
Do we have other public commenters?
This is anonymous number 3.
Just a moment, sir. Are you ready?
I am.
Go ahead.
Thank you very much. I would strongly agree with both the members of the committee and Mr. Warfield regarding the fact that these are absolute maximums. Whether or not this article means the section versus the entire ordinance, there has been found to be implied, even in the weaker CPRA, this notion of unreasonable delay. Even though the deadlines there are 10 and 24 days, if it was reasonable to produce it even faster than that, they are required to do so. And I know I've had cases where I asked for one email. I'm not asking for metadata. I'm not asking for anything complicated, just a single email. And they will use the full 10 days, or in some cases, 24 days, because they think that there's a 14-day extension. And that doesn't make any sense. So I think that that concept definitely should be in your letter. I would suggest, I don't remember if you've already made a motion or not, that your motion be that staff draft an email with the points and then include that draft in the agenda packet for the full task force. Because then both members of the public and the other 7 people on your task force have the ability to actually look at some work product and say yes or no, or amend it in specific ways. It also should be faster kind of in pipelining how many motions and meetings it takes for you all to be able to communicate with the full city. So I'd urge you to make a motion to draft a letter for sending to the full task force with a recommendation to send that draft with certain points. Thank you.
Next speaker. Any other public comment? Last call, public comment. Okay, public comment is closed. Yeah, I would, that was the intention that I would entertain in the motion, that we take the points that we discussed today, that we would agree on, and turn that into a draft to be presented to the full task force in August. And so everybody's got something tangible to read. And I will be happy to work on it, and whoever else wants to work on it with me. Okay, so is there a motion?
I can give this a shot. I can make a motion to create a draft to present to the full task force in August, to send a system-wide advisory about the time limits, considering 67.21 B, C, and 67.25D.
Okay, so let me clarify it a little bit. So it'll be 6721 B, C, and D, which that would include the time frame for the supervisor of records, and then 6725 as you mentioned, 6725 B. In addition, we will add to the preamble the last sentence. Well, I guess we can, yeah, the last sentence of 6725A. But we're trying to consider all the time frames in this. We're trying to create a bullet list here to include 25A. The other aspect is that we would also explain that there cannot be a conversion between a 6725 and a 6721 request. They exist independently. And what else? Is there anything else? I think that was it.
That's your whole motion?
Yeah.
All right, I'd like to read it back in case I've missed some language.
Okay.
Moved by member Padmanabhan. Are you seconding, Chair Wolf?
Yeah, I'll second it.
Okay. To create a draft to present to the full task force in August and send a system-wide advisory about the time limits in consideration of 6721 B, C, and D, that would include the time frame for the supervisor of records and 6725B. In addition, we'll add to the preamble the last sentence of 6725A.
Okay. I have one additional item that was brought up by one of the speakers, and that would be to include some language around that reflects 6721A with regards to unreasonable delay. And I think it was 6725.
There was one more sentence I was going to read.
Go ahead.
There cannot be a conversion of 6725 and 6721. Does that make sense?
Yeah, and we'll flush that out in the letter. These are just bullet points that we're identifying for the letter.
Okay, I can create them in the minutes into bullet points. But it is part of the motion.
No, please. We're only, this motion is really just to create the bullet points that we're notating here that will be used for creating a draft to the full task force as a recommendation from the committee.
Okay.
Yeah, okay. Yeah, that's it.
Okay. Do we want to take public comment on the motion?
Yes, let's do that. See if we left out anything. All right, this will be, I'm offering a second bite at the apple here, folks.
Thank you. Yes, please.
Mr. Warfield, are you ready?
Yes, please. And you'll give me 30-second warning and tell me when to start?
Correct. You may begin.
Right. Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and P.O. Box 170544, San Francisco, California, 94117-0544. And as I said it before, I say these things because I consider them important. The possibility of anybody talking to anybody else on a remote meeting like this is basically zero unless they have some way to get in touch, as opposed to what happens in a real meeting where you can walk up to somebody and say, let's exchange information. Basically, in general, I would approve of what you're describing. Absolutely, I agree with Anonymous that any draft should certainly be part of explanatory documents so that people can have maximum time to look it over and think about it, do any research they might want to, and so on and so forth. I think perhaps the chair was looking for section B where it starts. A custodian of public records shall, as soon as possible and within 10 days following receipt of a request. I don't know if that's what he was looking for, but it sounded like he was. And I have it in front of me and underlined. I wanted to say something about the importance of not converting. I appreciate that the chair says there is no conversion of an IDR. If I say it's an IDR, it's an IDR. All I have to do is label it properly. The only disqualification is if somehow I claim it's an IDR and I didn't mark it properly. And by the way, I think for the regular users of Sunshine, this would be very important and useful to point out that that's an option and how to do it correctly. I think people get very nervous about what's one, what's the other, what's the meaning, and so on. And I think that needs to be really clarified for lay users and even rusty ones. Turning something into a regular request is when it's stated in certain ways, I have seen this, very insulting and demeaning. It's a way for the respondent to imply that the person doing the request is not doing it right, is doing it wrong, doesn't know what they're doing, doesn't have the rights that they think they have. A whole pile of negative, actual and suggested communications. And that's completely wrong. And, you know, whether it's with attitude or without attitude, nobody did anything wrong if they said it's an IDR. And it takes longer than the next business day to respond to. So I think that's very important to leave out a way to basically mistreat the public. Thanks very much.
Do we have further public comment?
This is anonymous number 3.
You ready, sir?
Yes.
Go ahead.
Thank you very much. I would agree with most of what Mr. Warfield has said. There is one thing where he discussed how city employees use their wording to make it seem like you've done something wrong. Yes, they definitely do that. There's nothing really in the ordinance about anyone being polite or kind to anyone else, not on the public side and not on the city side. So I'm not sure legally what the task force could do about that. But I do think at least if they know that the task force does interpret the law this way, and it looks like that's literally what the words of 6725 say, you can't just convert them. It's just about the formatting and about a potential extension due to volume. That's exactly what the law says, and they should just do what the law says. Because I got a message from, I think, someone else who's on this hearing, I don't believe you are. Maybe I'm misunderstanding. This letter is not about what they're supposed to be doing during the COVID emergency order. My understanding is this is your dispute in interpretation between you and the city attorney and the good government guide of normal times, where they say, oh, there's this 14-day limit and they can be added extensions. I believe that's what your letter is, and how that letter interacts with how long the mayor's emergency order is going to survive, I don't know, but you may want to reflect that somewhere in the letter because people may be confused. Thank you.
Okay, any other public comment? Okay, last call, public comment. Okay, hearing none, public comment is closed. I would agree with the last comment, just to bring it up to current events. But generally, this letter is to be general. You know, whether it reflects the good government guide or not, what we want people to pay attention to is what we do and how we interpret the ordinance, and not how somebody else does. Because in the end, they're not going before a hearing, before the city attorney or some other body with regards to this. They're coming to the Sunshine Task Force. And also the fact that we put this out, and we've done this so many times, that also the only other body that gets to hear Sunshine complaints directly and by referral is the Ethics Commission. And I'm sure that they would, I shouldn't say I'm sure, but I could imagine pretty strongly that they wouldn't conclude otherwise than what the letter of the law is saying, because that's all we're doing, is we're just repeating what's currently in the law and how it's read in pretty plain English. Not much room for interpretation here. So that's all I got. We ready for a vote? Okay, let's call roll.
Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Member Yankee?
Aye.
Member Yankee, aye. Let me scroll back to the motion. Moved by Member Padmanabhan, second by Chair Wolf, to create a draft to present to the full task force in August and send a system-wide advisory about time limits in consideration of 6721B, C, and D that would include the time frame for the supervisor of records and 6725B In addition, we'll add to the preamble to the last sentence, including the last sentence of 6725A.
And then there's the part about the conversion.
Conversion of 6725 and 6721.
Right. And there was also the point I brought up about 6721A with regards to I'm sorry, 6721B with regards to as soon as possible and within 10 days. It's the as soon as possible part that will emphasize that.
And that's in 6721B.
B, with regards to as soon as, quote unquote, as soon as possible and within 10 days, unquote, as emphasis.
Okay.
All right. Call the roll.
I did.
Oh, okay.
We're on item 11.
Yep, item 11.
Item 11, announcements, comments, questions, and future agenda items by members of the Education, Outreach, and Training Committee.
Anything for the good of the cause? Okay. No discussion, no action. Let's move to the next item.
Item number 12, adjournment.
Are you having public comment on that item, please?
There is nothing to comment on.
I believe every agenda item is supposed to take public comment opportunities.
I believe it's for action. A moment. All right. Well, I'll allow it. I read the ordinance as being only for action items unless there were items for being discussed. That there was no items to be discussed in an area. It's just not another opportunity for open for general public comment. We have a whole section for general public comment for that. But considering this is a short meeting, there's only 2 commenters here that I can see. I'll allow it. I'm not generally of the mind to do that, unless there was some discussion from the task force. So open it up for public comment on this item.
Thank you. You're going to tell me when to start and 30-second warning, right?
Correct. You ready?
I am.
Go ahead.
Thank you. It's Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and also at P.O. Box 170544, San Francisco, California, 94117. which might be useful for the 100,000 plus people who don't have easy access or any access to the internet and might want to get in touch. And I consider this important, as I've said, because it simply replaces the basic democratic concept of free speech amongst folks at a meeting and the possibility of it. Pretty simply, thank you for letting it happen to public comment. I think it's very explicit in the law. But in any case, rather than argue that, thank you for this change. What I want to say is, I mentioned it somewhere, I would like to request that our successful complaint against the Library Commission be taken up very specifically at preferably both the Education Outreach and Training Committee and the Compliance and Amendments Committee, because I can tell you that the very meeting right after the June decision, 2 or 3 weeks later, there was absolutely no change whatsoever at the Library Commission. They had the same wrong instructions. They had apparently the same procedure. They had, as I had described at the complaint, made 2 small changes, but important, one of them in particular, prior to the meeting, but well after we had filed our complaint, and it seemed as though they didn't do anything until they were specifically shortly going to be heard at a task force. Their reason for the problem seemed to be just technical issues, which they were completely unclear about what they were or what they were going to do to fix them. And as I said, they haven't changed anything. And so I would ask that this be taken up. It's very critical. It is affecting every other meeting that the city has, pretty much in terms of what opportunity are they giving for public comment, and is it a reasonable and a fair one?
30 seconds.
I made a number of suggestions during the meeting and also in the material we provided. I may be learning more and more as we go. I think there's one new thing that they've done, which I could discuss. But I think that these things need to be really looked at and taken apart and figured out, what is the standard? What is the standard you expect from a remote meeting for public comment to be given, for folks to be given a fair opportunity? Thanks very much.
Next speaker.
Anonymous number 3, please.
Go ahead, sir.
Thank you. This is about what has been discussed by the chair of this committee as potential future agenda items in the past, and I just don't know what has happened to them. So I would urge this committee to agendize them. They were very similar to the item you just heard about system-wide advisories. There were a few other system-wide advisories that this committee, and I think maybe just its chair, have recommended about calendars, about remote meetings, about redactions and keys to redactions. Imagine how many fewer complaints you might have if the real reason that people don't do this is they just literally don't know that the ordinance requires you to do all of these things. And so I'd urge the committee to urgently agendize those potential system-wide advisories that it had itself discussed as future agenda items. Thank you.
Any other public comment? Seeing none, public comment is closed. Thank you. Please call the next item.
Item number 12, adjournment. I have 7:29.
Is there a motion to adjourn? You don't want to leave?
I'll move to adjourn. This is Member Yankee.
And I second it.
Second by Member Padmanabhan. And all those in favor say aye.
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 Opposed? We are adjourned. 7:30 sharp.
All right, let me stop the recording.
Good night.
Good night.